So, when anything, any claim, any matters is brought against you, or if you bring in one, burden of proof is basically what causes people to get their asses kicked. Especially if you're the one bringing the claim. If you're the claimant, they would tell you that you have a heavier burden of proof. And if you're going to point fingers, you better have facts. Show something that's essential, meaning the essence of what you're trying to say. Show something beyond what you're saying that would prove what you are saying. The substance of it. The substance are your evidence. So when you hear things like material fact, probative value, certain types of evidence with probative value or preponderance of evidence, they're just telling you bring in substantive evidence, substantive fact. When you create your affidavit of truth, evidence still has to back that up. It stands on its own because you swore an oath to it and it has to be rebutted, but it has its power and strength reaches farther if you have evidence to back it up. Regardless of whether you're plaintiff or the defendant, burden of proof is extremely important. So material facts is a fact that is important, significant, or essential to a reasonable person in deciding whether to engage or not to engage in a particular transaction, issue, or matter at hand. So if you're bringing things to a neutral third party like the acting judge, or for instance a jury, because juries are the ones who find the fact in the matter. They are the true fact finder. When you read certain verbiages of rules of evidence or certain verbiages of certain stare decisis, they will constantly use these words fact finders. When they talk about fact finders, they're talking about the jury. In fact, there is a maxim of law that talks about the fact that acting judge only deals with the law. The jury deals with the substantive fact. And let me see. There it is right there. There's the Latin. There's the English correspondence of that maxim. The judge answers to the law. The jury to the facts. So, and this law is basically based on the office of trust and the position based on their oath of office. Some state constitution clearly lets you know that they have a position of trust. In Minnesota, it's Article 13. It tells you clearly. In Illinois, it's kind of vague, but nonetheless, it lets you know in the preamble, and it's scattered all over. So, people love jury trials, and maybe that'll be in another video, but you can actually pick your own jury. When they talk about having the ability to pick a jury of to be heard by a jury of your own peers, that's never going to happen. They will do something called a voir dire, which is just another Latin word for like a separate hearing that they engage in order to pick the jury. But it can never be impartial if the prosecuting attorney is the one picking it on your behalf, or they're hand-picking people that's going to benefit them. But you can actually create your own questionnaires to hand to these juries and select it yourself. A lot of people don't know that, but that's a whole nother thing. But nonetheless, material facts is important to the jury. A lot of people know the importance of juries and the fact that they are the judge and the people. And the people granted these acting judges who are officers of the court based on the substantive law, which is the Constitution of the state. So before you even get to all that voir dire and all that, you have to deal with material facts. Bring your evidence in and show it. And the best way you can do that is learn how to do research, cross-reference things. It is extremely, extremely important. because now you can just take pictures of those evidence and just put in and label it as material fact number 1. Whatever it is you want to do, just do that research and put it in his face. For instance, lawyers and attorneys, they are the main actors that attempt to stop you from getting the remedy you seek. If you're dealing with mortgages, they want to take that and recycle it into the system, get their commission, and you're at loss. If you are dealing with child support, attorneys are the ones who bring the claim against you. If you are dealing with traffic matter, failure to identify, all that, the trivial things, it's usually these prosecuting attorneys. Say you figured out, oh, he's an officer of the court, conflict of interest. Well, how do you show that? You have to learn how to do research, find their attorney number, find his international standard lawyer number, find the university he graduated in. Take a picture of all that. It's available on the internet. It is available. Take pictures of all that on its face. Right there, that is a functional evidence of conflict of interest. And then add that, do the same thing for that judge, that acting judge. And there you go right there. That is your material fact. If the subject matter is the fact that you're invoking conflict of interest and lack of impartiality. So that applies with any other situation. For instance, people that go into settling insurance matter in public courts, you have to take pictures of the car, the dent, the color, the scratch, all that, right? That's material fact. You do the same thing with any other matter. Just use that same logic and carry it around. So another word that we use for material fact, which is just basically the significance and the essence of what you're saying. And oftentimes it's best that it be face value, meaning it can be observed by a fact finder. And most juries in today's world, especially in North America, they don't really know much about substantive law or positive law. So you have to sympathize in a manner whereby you would approach things in a manner whereby if you're dealing with someone who knows nothing, but if you present the facts right on his face, they will see it undisputably that, oh wait, something is wrong. That's where your research comes in with that example that I just gave. So if you're trying to say, hey, look, you guys being my last line of defense and you guys having the power as a jury, there's a conflict of interest here. These guys have been screwing me over, and this is why and how. Just take those images and those evidences, put it into material fact or material evidence. Show them. Another term they use for material fact is probative value. The ability of a piece of evidence to make a relevant disputed point more or less true. In a trial of a defendant for murder, the defendant's dispute with his neighbor has no probative value because it provides no relevant information. It's a trial of the fact. Remember, the trial of the fact is the jury, based on maxim of law. They're not going to tell you here, but this is the substance right here. So basically, relevant information. So you have to be able to do your research and just put these things right in his face where it is. So this is significant and essential things that a reasonable person, aka the jury, probative value, relevant information, same thing. Another word that we use is preponderance of evidence. Type of evidentiary standard. Evidentiary standard meaning federal rules of evidence or the state rules of evidence or maxims regarding evidence when it comes to law or equity. Remember burden of proof that I was talking about? It's all about proof. It's all about substance. For further reference, when you look at Bouvier's, what edition is this? This is the 6th edition. talks about materiality. And ity is just a state of being. Just a suffix. It's just a state of being. Suffix ity is an abstract noun expressing a state, condition, or quality. Remember, we're talking about material facts, which is the substance, which is the preponderance of evidence, which is the probative value. So, Bouvier's dictionary lets you know that material things are the important things, which is not just by form, meaning they cannot just tell you that your material, your evidence, or the main thing we're looking for to decide whether what you're saying is true or not to favor you. It cannot be based on court forms or court pleadings or any technicalities. It's the substance. What is the substance of your claim? If your claim has a substance, then there's no need to argue, because all attorneys do is just argue. Even when you look at their papers, they will outline everything, and then the first thing they will start with is background, and then the next thing is argument. Literally, on paper, they will write it arguments. So they're showing you they are arguing with you. And if you have substance, nobody can argue with you because there's nothing to argue about. So put your material fact, put it into evidence, put it through judicial notice. Label it as material fact number this, material fact number 1, 2. Literally label it. So now it is undisputed that that is a material fact. It goes on and gives you an example. When a bill of discovery has been filed, for example, the defendant must answer every material fact which is charged in the bill, and the test in these cases seems to be that if the defendant should answer in the affirmative, his answer will be of use to the plaintiff. The answer will be material and must be made. So if you do interrogatories, which is a form of discoveries, or if you just do a general discovery, which is usually limited between a certain point of the trial or before the trial, whatever their response is, put that into evidence and label their response as your material evidence. So just a little tidbit. Put things in its face. Take pictures of things and put it in its face. Label it as material fact, or label it as probative value, or label it as preponderance of evidence. Literally, use these words. Put it right in its face. But research is the important part. Do research. Learn how to research whatever your claim is. Learn how to do some deep research so that you can find these things. Most of us deep down know something is wrong and that something is not right. We feel it, but even when we're able to articulate it, we're still not able to prove it. But all you have to do is just stop for a moment and think and just find it. It's out here. Everything you need to kick their ass is out here. And the law actually favors you. The everyday motherfucker. Believe it or not, it favors you.